Hello, my name is April. Thank you so much for tuning into this webinar today on the top legal docs you need for your e-commerce business. I'm very excited to be here today. It's my first webinar for the Like-Minded Bitches community. And being an e-commerce business owner myself, I've recently joined the community and I'd love to be able to give back and share some of the knowledge that I have in my particular area of expertise. So who am I? I am April Thomas. I'm a commercial lawyer with 15 years experience, and I'm the co-founder of a legal document template business called Cherrypicka Legal Docs. I work a lot with small businesses like yours, and I'm hoping to take some of the myths and the scariness out of the law today to give you a really good roadmap of how you can de-risk your e-commerce business. So what are we talking about today? First thing I'm going to run through really quickly is why do I need legal contracts? I do hear a lot that people shake hands with their suppliers and they feel like they have a really good relationship. So why would you need contract in place to just complicate things? Well, unfortunately, I get involved in the back end a lot and I see when things go wrong. So I'm going to talk you through why contracts are really important. Secondly, we're going to talk through what a really good, solid legal foundation looks like for your e-commerce site. Then I'm going to talk through the risks of downloading stuff from the internet, as well as asking ChatGPT for the answer, which is quite topical at the moment. And then finally, where you can source legal documents and how you can find yourself a good lawyer. There are some things I'm not talking about today, but I really do want to raise them up front because they are still important considerations for your e-commerce business and possibly something that I can do as the topic of a later webinar. The first one is structuring. So it's very important when you start out that you think about what is the correct legal structure for your business. If you're going alone, you could be a sole trader. If you're working together with a partner, do you have a partnership? Do you have a company structure? Do you need a shareholders agreement between the owners of the business? These are very important considerations and something you should probably talk with your accountant about. Secondly is intellectual property and branding. As someone with a lot of experience in IP, I can tell you that this is a really risky area. If you're about to launch a business and it's got your branding all over it, please check to see that you have clearance to use that branding and you're not going to be infringing someone else's IP. It's very expensive if you launch and then you get a nasty letter from someone else telling you that they already own your brand name and you need to go through that process of changing everything. I've seen it happen. It's awful. Please check your trademarking. Another topic that is very important that we're not covering today is the Australian consumer law. And I encourage every small business e-commerce owner to jump onto the ACCC and really familiarise yourself with the returns, refund, repair policies that the ACCC mandates, because this will impact upon your refund policies. And finally, we're not going to look at leasing. As you expand, you might need to take on a premises and you will need to have those leases checked and reviewed. These are all important considerations and something that we might look at another time. So why do you need a legal contract? As I said before, I hear these things all the time. Tell me if they sound familiar. Contracts are for large companies. Contracts are boring. Legal jargon is intimidating and overwhelming. Can't I just put a few dot points down in an email? Or I have been friends with the supplier for years. They would never do anything wrong by me. Unfortunately, I come in on the back end and I see when problems occur. And my clients so often wish they could go back in a time machine and put a contract in place at the start of the relationship. It might seem annoying and boring to do, but trust me, it is worth it in the long run. So why do you need contracts? Firstly, it sets the expectations of each person up front because it's much better to have those difficult discussions at the beginning and make sure you're really clear about what you're providing or what you're receiving, how much you're paying, rather than having a nasty dispute later down the track. It makes you look professional. If you go onto an e-commerce website and there's no refund policy, there's no terms and conditions, and there's no privacy policy, it really brings into question the credibility of that site as far as I'm concerned. As I mentioned, it can help prevent disputes and it also protects your reputation. I think as a small business, reputational damage is often a higher risk than the risk of ending up in court. So if someone is bad mouthing you online, a supplier, for example, or a customer, and you can point to the contract that they entered into and the terms that they agreed to beforehand, that can really help protect your reputation. So what contracts do you need in your e-commerce business? The way I like to look at contracts is by looking at the legal framework. And you look at each interaction that you have as a business owner and you ask yourself, do I need a contract governing the terms of that relationship sitting behind that interaction? So if you have a look at the slide here, your business has a number of different stakeholders. Most importantly, you have your customers. So these are the people that are purchasing your products. So we need to think about what contracts we need to have in place with them. You would have a manufacturer making your products or who you're purchasing your products from. What contract do you have in place with them, if any? Your service providers. So these are people like your digital marketing agency, your freelance designer, or your PR agency, if you have one. Do you have a contract in place with them? Another really important one, and something that I see issues arising with all the time, is your influencers. Please have a contract with them. I see so many issues arise with influencers not following through. So we'll talk about that today, as well as your employees. When you first start out, you might not have any employees, but as you grow, employees, hopefully, is something that you will need to look at and employ. So we will look at the contracts that you have in place there. But firstly, I'm going to start with what I like to call a hero document. And this is a confidentiality agreement. You should consider putting in place a confidentiality agreement with any of these stakeholders that we talked about before you enter into the formal legal contract with them. And it's really important because a confidentiality agreement protects any confidential information that you have or secrets about your designs or your brand or your marketing plan or your financials. And by having a confidentiality agreement in place, it means that the person who is receiving that information can only use it for a particular purpose. So let's have a little look in more detail about a confidentiality agreement. A confidentiality agreement, or sometimes known as an NDA, is used when confidential information needs to be shared between two or more parties. It is really helpful to put in place before you have commercial discussions with another person. And there are a few things that you need to consider within it. So I'm going to give you an example. Say you are looking to engage a designer to help you with some products for your e-commerce business. Now, in order to have these initial discussions with various designers, you need to share some information about your product line and your ideas and your inspiration. But you haven't selected which designer you want to engage yet. So before you meet with that designer, I would put a confidentiality agreement in place to say that the designer can only use the information that you share with them for the purposes of providing you with a quote for the design services. Now, once you've selected the designer, then we can talk about what is the right contract, but that will protect those really important pre-contract discussions. So please do not forget about the beauty of this little document and how helpful it can be when you're in business. The next relationship we'll look at is the relationship between you and your manufacturer or your supplier. I think one of the key issues when you're dealing with a manufacturer is you could be providing them with really important drawings or designs that you want to keep confidential. That's your intellectual property. So let's have a look about how a manufacturer agreement could help you with those things and some other things. So a manufacturing agreement would include things like the process for placing your orders. When is payment due? Are you going to pay the manufacturer before they produce the goods? Or are you going to pay them half up front and half when the goods arrive or are dispatched? By being really clear about these things, you're going to prevent the risk of disputes going forward. When is payment due? We covered the time for delivery. This is really important. How long are you going to give the manufacturer to make your goods and to have them arrive? Because that can have consequences at the back end for the sale of your products. When does title and risk in the goods pass? This is another important question, because it means, when do you own the goods? Do you own the goods once they arrive in your warehouse, or do you own the goods once you've paid the manufacturer? And obviously, owning the goods once you pay the manufacturer is the better option, because that is less risky for you. The other one is, when does risk pass? So if the manufacturer sends you the goods, do you then have the risk for those goods from the minute they leave their warehouse, or do they carry the risk in the goods until they arrive on your doorstep? These are really important things that you need to be clear on, because that can depend on, what type of insurance you have and when your insurance kicks in from. Another thing you'd want to include in this agreement is warranties. Manufacturers will often try to say they have no liability for the goods that they're creating. Now, if these manufacturers are located overseas and the contract is governed by a different jurisdiction, such as China or Vietnam, then there's no sort of regulation around those warranties that they need to put in place, even though you're a small business. So I would be looking for them to warrant or guarantee in your contract that you put in place with them that the goods are of a particular standard, that they meet your specifications, that they are fit for purpose. You want these reassurances from your manufacturer, so you can turn around and claim off them or go back to them for assistance should some of the goods or products be faulty. And then finally, as I said earlier, the intellectual property and confidentiality is really important. I have had a couple of clients who have engaged manufacturers overseas, have shared their designs, have not had an agreement in place, and then have turned around 6 months later to see their designs having been produced for someone else, which is a risk. By having the clauses in the manufacturing agreement which say that you own the IP, that it's confidential in those products and those goods, then they're unable to recreate them and sell them elsewhere. The next contracts you need to consider are those between you and your customers. I'm not talking about a written formal contract between each customer, but more so the documents that would sit on your website that govern the sales process, the refunds, the returns, the shipping, and all of the practical details that your customer is going to want to be aware of. So the first one is your e-commerce website terms and conditions, and these T's and C's serve two purposes. Firstly, they set out the rules for the visitors that visit your website, and they protect you if something happens when the customer is on your website, like a virus, for example, and they would limit your liability in that regard. Secondly, they would set out the terms of sale of your products. So I'm talking about things like payment. How is payment made? What the prices are. Do you have the right to vary the prices on the website? The delivery terms, the liability and the description of the product. So often you would say something like, whilst we use our very best endeavours to describe the products in the correct way, the computer screen might make a product look a slightly different shade than the product that is going to arrive. While there are some Australian consumer law issues there as well, you can use your terms to sort of set the scene around some of these things. So they're a really important set of T's and C's that you need to have in place, before you start selling through your website. The next one is a privacy policy. Now, not all small businesses need to have a privacy policy. You do need to have one if your business has $3 million annual turnover or more, which we can only hope your businesses will get to that level. Or you provide a health service or hold health information, or you're a Commonwealth contracted service provider. Now, if you don't fall into those categories, you don't technically need a privacy policy, but I would recommend it. There is so much in the media at the moment about privacy, cybersecurity, what's happening with people's information. Actually, just a really good process for you to go through to have a privacy policy and to think through those things. How are you going to store personal information? How long are you going to keep it? Do you need to keep names and addresses? If you haven't engaged with those customers for years or they're not actively engaging, you should delete that information. There's a lot to think through with a privacy policy, and I do recommend that you have one on your site, as it does increase that credibility with your customers as well. The next document that I would recommend you have on your website, and it does feed into that earlier doc about the general terms and conditions for your website, is your refund, shipping, and delivery policies. Now, with the refund policies, it's really important that you understand your Australian consumer law requirements, because these can be really tricky to navigate. A good returns policy should be compliant with the Australian consumer law and should tell customers when they have a right to request a refund, repair, or replacement. I think it's important to note here as well that there is a misconception sometimes that you have to offer a change of mind. Well, for an online business, it is a good idea and can be a good selling point when customers can't try on the goods. You don't actually need to give a change of mind refund. You can give a credit note, exchange, and the like. Other things you can set out in your returns policy is where there are hygiene. If there are hygiene issues, if you're selling swimwear, for example, you might not want to offer a change of mind for those particular goods, or earrings. This is a great place to just be really clear on all the expectations, but keeping in mind that fundamental obligation that if the good is faulty, then you do have that obligation to return, replace, repair. Another thing to set out is your shipping and delivery policies. So in there, you could set out the estimated timeframes in which the customer would expect the goods and any associated fees. If you're unclear about any of your obligations around refunds and returns, jump onto the ACCC website. It has some fantastic resources on there that I think really clearly explain the position. The next type of agreement that we're looking at is supplier agreements. So these are the agreements between you and people that are providing you with services. So I'm not talking about the goods, which is more that manufacturer-supplier relationship. This is people that you're receiving services from. So here I'm talking about your digital marketing agency or your PR agency or a freelance designer. So they're not your employees, but they're people that you're using to provide you services whilst you are conducting business. What is really important about these agreements is they help set the standards that you're expecting to receive. You can be really clear and upfront on what the deliverables are and what the scope of what you're getting is. You can be really clear about how much you're going to pay the service provider for the services. Again, intellectual property is a really important consideration here as well. If you've got a digital marketing agency creating a whole bunch of content for you, you want to make sure you own that content, not them. And by having in place intellectual property clauses in your contract, you can be guaranteed that the intellectual property or the content that they're creating for you is owned by you, and that then you can reuse it in whatever way you like. A supplier agreement would also set out termination. So how much notice do you need to give the service provider to terminate their retainer? Ideally, you'd want that to be 7 days to give you flexibility or some short period. And would also set out the liability that they have. So often suppliers will try to limit how responsible they are to you for the services that they provide. You want to make sure that they're standing behind their goods and services and that you could claim loss or damage from them in the event that they don't meet the expected standards. So an independent contractor agreement is often a good fit for this type of arrangement. If you're asking a lawyer for a document, that's probably what they would provide you when you're engaging service providers. But it is really important that you just check when you are engaging service providers, particularly if they're an individual, that you're not stepping on that very fine line between a contractor and an employee, because if they are an employee, there are different obligations that you will have, and we're going to cover that shortly. Something else I should raise now too is that suppliers or service providers will often give you a set of their own terms and conditions. It's really important that you read those before you sign them, and if you don't like them, please make requested changes. So if you're not happy with the payment terms, if you're not happy with the fact that they say that they own all the IP, you can say no to that, and you could either give them your own contract or you could negotiate some changes to their own contract as well. Please don't have their terms and your terms because then it gets confusing. You want to be clear on whose terms and conditions you're using. It's always my preference that you use your own, but sometimes that's not possible, the speed that you need to work. So just make sure you are reviewing their terms if they're giving them to you. Finally, I'm going to give a short note on employees. So you may or may not have employees. I think if you've got a really small micro business, employees is something that you might grow towards having in the future. But if you are looking to hire employees, there's a few considerations that you'd need to think about. It is an area of law that changes rapidly, so I'd be really careful if you're using templates that you're finding online just to make sure that they are up to date. There are some recent changes that are coming into play in December of this year around fixed term contracts. So that governs the amount of times that you can renew a fixed term employee's contract. And as well as some family and domestic violence changes as well, which are coming in place in August 2023 that are going to impact on small businesses. So please make sure that your employment contracts are up to date, reflecting these important changes. It's also really important that you choose a contract that is correct for the type of employment relationship. So there's permanent employees. Those employees have no fixed end date, or there's fixed term employees who you might hire for, say, a period of 12 months. There's part-time employees versus full-time employees, and then casual employees as well. So you need to choose a contract that is fit for purpose for that particular type of employee, because the government gives different types of entitlements in relation to each one. Something else to consider if you're hiring an employee is whether or not you're going to put a restraint of trade in place. Now, typically these are reserved for more executive level employees. But say, for example, you've been working on something top secret with an employee, and then they hand in their resignation, and then the next week they go and work for a competitor. You might want to put something in your contract that would prevent them from going and working directly with a competitor for, say, a period of 4 weeks or 6 weeks. But if you're going to be using those restraints of trade, it's probably recommended that you do see a lawyer, because there are some legal considerations that you need to take into account about how long those restraint periods can be for them to be enforceable. On to something a little more exciting now, and these are the agreements between you and collaborators. So what I would be looking to see here is a collaboration or an influence agreement. And I thought it would be a bit of fun to pull out some quotes around experiences that people have had in working with collaborators. So this is something: advice needed, re-influencer ghosting after paying invoice and gifting product. The next one here: last week we did our first paid influencer promotion. To be honest, it was disappointing. I've always really liked this account. I thought I'd ask here to clarify a couple of things and see if it's the norm or not. The third comment here: it's been 2 months and she hasn't opened my messages and hasn't posted a thing. And finally, I desperately need some advice because I've once again run into a dead end with an influencer. Influencers get a bit of a bad rap. There are some fantastic ones out there. There are some not so good ones. But I think irrespective, by having an influencer contract in place or a collaboration agreement, you are setting the tone with the influencer upfront that you mean business. And I think you get a really good sense whether an influencer is serious as to whether they're going to deliver on their promises, as to whether they're prepared to even go down that path of signing a contract. So what would you need in a collaboration agreement? Firstly, it's really important to set the deliverables up front. So what will the influencer create? Set out clearly what content are you requiring from them? Is there any key messages? What are the timing? When are you expecting them to post? And are there any hashtags that you're wanting them to use? Set out the amount that you're going to pay them, or what contra or gifts you're going to provide. And that's really important too. Don't just sign the contracts when you're paying them. If you're gifting products, this can be at a high cost to your business as well. So you still have a contract for those type of influencer arrangements. Another important thing to include is how you can use the content that they create. So are you planning to use it on your own socials? Would you like to cut and paste some of their works and use it on your website? Without specifically spelling these things out, this can lead to some disputes down the track. And they could claim that no, it was never intended for those purposes and it was just intended for their own socials. It's really important that they disclose the commercial relationship because this can have implications on you too. And there is a lot of eyes on this area of law at the moment. You must disclose commercial relationship by using appropriate hashtags or the paid sponsorship tools that are now available on some of the various platforms. Is there any exclusivity? Are you requiring the influencer to not work with any competitors during the term of your contract? And whether they need content submitted for pre-approval. That can be really useful in more high-risk industries. So if you're dealing with cosmetics or medical devices, where you know that there is regulation by authorities such as the TGA, you might want to get more involved in the content that they're creating to make sure that you're not going to run into any roadblocks or regulatory issues. So please, let's avoid those nasty collaboration issues and consider getting yourself a collaboration agreement. The next thing I'm going to discuss just briefly is, can I just copy stuff online, April? Or can I just ask ChatGPT for a contract? I am smiling, but it's something that I hear all the time. And I think there is so much stuff available online, but when you're dealing with legal documents, you need to be really careful that you're getting legal documents that comply with Australian laws, and B, that they're up to date. Law changes all the time. You want to make sure that you're using credible legal documents and not just downloading stuff online. And I thought I'd use a little example. I asked ChatGPT to draft me a simple refund policy in Australia. And what it said was that if you wish to return an item for a refund, you must do so within 30 days of the purchase date. It must be in its original condition and packaging. Now, this is interesting because as it stands, this is in contravention of the Australian consumer law. If you wish to return an item for a refund and that item is faulty, you cannot prescribe a set period of time for that item to be returned. Why? Because the law says that the time in which you can return a product must be considered reasonable in relation to the nature of the product. So the amount of time that would be reasonable to return a moldy loaf of bread would be completely different to the amount of time that would be reasonable to return an expensive television. So by putting 30 days, you're in contravention with the Australian consumer law. And in fact, this is an issue that recently tripped up global giant Booktopia in terms of their own refund policy by prescribing that set period in which they had to return a product. They ended up with some quite significant penalties. So please be careful using ChatGPT. I know it's tempting. I love it. I think there are some great ways to use it, but just please exercise caution in relation to legal documents. The next slide is, how do I find great documents if I haven't got a lot of money? And how do I find a lawyer that I like and I'm happy with? So I think the first starting point is, as I said, there's a lot of templates available online now. I'm sure you've all seen a variety of templates out there for these base legal docs, and templates can be great. I think if you find a credible template provider who is basing their documents on Australian law, and please check that there are a lot, if you type legal templates in, you could be downloading a legal template from a different jurisdiction. And I've seen that happen from time to time. There are also times when you need a human, and obviously seeing a lawyer is always the best, funds permitting, if you've got the money available. So I thought I'd just run through quickly how to find a good lawyer. This is not based out of self-interest whatsoever, just generally speaking, I think it's really important to find lawyers that offer you fixed fees. So you want a contractor agreement drafted, please tell me how much this is going to cost. So you've got that full price transparency and you're not being charged by the hour. Shop around. There's no shame in that. Get a few quotes, see who you like the most and who you're happiest with and who you think understands and gets your business. and ask for discounts. I've had clients a few times say, I need this speaker agreement drafted. My budget is $2,000. Can you do that? And good lawyers who are trying to offer value will often come to the party on those type of arrangements as well. So there's some tips for finding good legal docs and a lawyer. As I said, starting an e-commerce business is loads of fun. It's exciting. It's a very dynamic and fast-paced area, but it is so important that you get those fundamental legal documents in place, as they are going to hopefully make business a lot smoother for you and really minimize that risk of both legal and reputational disputes. So I'm going to do another webinar in a few weeks on dealing with collaborators. So I'm really going to deep dive into a few more of those issues. But I hope I've made law a little bit more lovable for you today, and I've really enjoyed this. So thank you very much.